The position simply is that for all that we have done as a court, the entity to give effect to it is again Parliament itself. So it's like a journey to nowhere.
Really?
Yes. It's like a journey. Now Parliament will be called upon to enact regulations or orders to give effect to this. What will Parliament do? Because our duty will be to give effect to this. But how are we going to do it?
Okay.
You understand? So the interpretation, the whole judgment for me failed to give critical analysis to the peculiarities of Parliament.
You are worried that the court respected the language of the Constitution? Because that is clear.
No, the court didn't respect the language of the Constitution.
Think so?
I think the court rather, for me, interpreted the constitutional language in a manner not purposive of the framers.
Okay.
Because the framers had a purpose to put all those provisions. And finally, the language on page 23, the use of opportunistic absence is a problem for me. For a court, not just any court, but for the Supreme Court to use this language in respect of the office of the speakership amounts to me imputing improper motives. Because you see, the speakers of Parliament, the substantive and the deputies, when they are absent for a good cause. But we are suggesting that for some ill purpose, somebody could decide to be absent without reason.
It's very possible.
No?
It is possible.
But you cannot impute improper motive.
But that's not what the judgment said.
That is why you suggest.
It is likely.
What is likely?
There's a possibility.
Those are the things you don't say. Those are the things you don't. A court shouldn't be saying those things without evidence. When you have evidence, be categorical. Don't be suggestive.